Hello, folks. Attorney Josh Berkley here again, and I want to talk with you a little bit today about the probate process and what you can expect if, unfortunately, a loved one passes away and you need to avail yourself of the court system to get all their assets transferred. There are basically about 5 steps to the process. In step number 1, we kind of gather all the information and try to make sure that you've got the original will, any trust that you might need, and also any documentation regarding assets such as bank statements and deeds to real property. Okay. In step number 2, your attorney will do the drafting. You're going to petition for probate. That's going to allow you to kind of get the process started with the court. And you'll also be petitioning for the appointment of a personal representative. That's either an administrator or an executor, depending on whether or not there's a will. And that's, of course, the person that will then be managing the estate, writing checks to pay the bills, just taking care of all of the affairs that's involved in managing an estate. Once all that drafting is done, that paperwork is filed with the court, and a court date is set for the judge to then formally appoint that person as the executor or administrator. Generally, what we do is our office, one of our attorneys will get a limited power of attorney and appear on that person's behalf. The person that's becoming the executor or the administrator don't actually have to go to court themselves. We can go as their attorney on their behalf and get them formally installed as the personal representative. That would be step 3. After that, the 4th step, and this is the longest one typically, is gathering together the assets. Okay, we're gonna once the court sends out the order appointing the personal representative, we're going to gather the assets together, whether they be physical things that need to be kind of gotten together, put in storage, things of that nature. More often what we have is bank accounts, and we're going to open an estate bank account. It'll have its own tax number, and we'll put all of those assets into the bank account. Again, that would be step 4. The last step, closing the estate, we look to see which creditors have filed claims against the estate, see which of those need to be paid. We also look to the beneficiaries of the estate and see how we need to divide up the remaining property amongst those beneficiaries. Once we have done all that, we always have the beneficiaries sign off on a receipt and a release of the personal representative. That helps us just to kind of wrap everything up nicely. The attorneys then draft up the final documentation that needs to be filed with the court, often called a settlement, which can be formal or informal, depending on if everybody is in agreement or not. And once we get that settlement all drafted, filed with the court, so long as there's no objections, and many times there are not, that actually closes out the probate process and releases the personal representative then from their responsibility as the fiduciary over the estate. So that's a real quick version of the probate process, but a lot of times folks come in to see us, they're just a little confused. They've never had to deal with this before, and there's no reason that they would already know what to do, and that's what we're here for. So in any event, if we can ever help you out with any probate matters or questions that you may have, please feel free to give us a call. Thanks.